Thank you for signing up for our 5-part series on estate planning. I am attorney Mike Monteforte. I am the CEO and managing attorney here at Monteforte Law. We focus on moderate to high net worth individuals and families, helping them protect their legacy, protect their assets, and passing on wealth to the next generation. Stay tuned for part 1 of our series where we're going to be talking about your last will and testament. Welcome to part 1 of our seminar. In this section, we're going to be talking about your last will and testament. Now, here at Monteforte Law, we have what we like to call your big 3 documents, and these documents make up the central hub of any estate plan that we do. Additional documents like trusts build off of that hub, and those big 3 documents are your last will and testament, a durable power of attorney, and a healthcare proxy. So first we're talking about the number 1 piece of that big 3, which is your last will and testament. Now most of us are familiar with what a will is and what it does. It's where we write down in legal writing where we want our assets to go if we were to pass away. These documents can be very, very simple. If I were to pass away, I want everything to go to my spouse. If my spouse predeceases me, then shared equally among my kids. Or the documents can be very, very detailed, where you're naming specific property that you want to go to a specific person. And you can make a list, it can be as long or short as you want, where you're stating clearly what's going where. For most people, it's a combination of the two. We keep the base document pretty simple, throwing most of the property into the pot and dividing it as you see fit. If you have specific items of either high monetary value or of sentimental or personal value, those items can be specifically listed out in detail for where you want those items to go if you pass away. That might be things like jewelry or family heirlooms. Now, someone needs to administer your will for you when you pass, and that person here in Massachusetts is called a personal representative. Years ago, the term that we used was executor, and that's still the term that we use in conversation because it's what people are most familiar with, but legally you won't see the word executor in an updated will at all. You're going to see the word personal representative. And you need to name somebody to be your personal representative. That can be your spouse or another family member, and it's important to also name at least one backup person, just in case your primary person isn't available, can't do it, or may have predeceased you. Another thing that people often overlook is our last will and testament is a place where we can name guardians for our minor children. So if you were to pass away and you've got children under 18, someone needs to take charge and be the guardian for those kids. Our last will and testament is a place where we can give our wishes as far as who we want to replace us as parents and bring up our children for us. So appointing a guardian is a very, very important part of your last will and testament. Now here in Massachusetts, we have strict rules when it comes to your last will and testament. The document must meet Massachusetts' strict requirements in order to be approved as a valid will by the probate court. So if you think you can just write down your wishes on a piece of paper or on a napkin, sign at the bottom, and that will is going to be legally binding, you're wrong. That's not going to happen. The will must meet Massachusetts' strict guidelines in order to be valid. So this is not something that you want to do on your own. You definitely want a qualified attorney to help you with your last will and testament. Stay tuned for part 2 of our seminar where we're going to be talking about another piece of our big 3, and that's the healthcare proxy.